Good afternoon, everybody. It gives me immense pleasure to welcome our speaker, Professor Joseph Raz, and also to extend a warm welcome to those attending, friends and colleagues from the law faculty and wider parts of NUS, and indeed from outside. A warm welcome to all. Not so long ago, a couple of years or so, somebody was trying to find a way of introducing the eminent speaker who was about to address a gathering at the Library of Congress. And it's always very difficult with somebody of Joseph's stature to try to capture something that is distinctive of all their many accomplishments. And on this occasion, the introducer resorted to an image of a mountaineer scaling the many peaks of jurisprudence, taking us to heights that others would dismiss as unattainable. And although I think that's a fair reflection of his work over many years now, the variety of his output and the attempts to question issues that others would prefer to ignore or make assumptions on. But I somehow felt this wasn't quite the right image. And over the past few days ruminating on this, I think although scaling the heights is there somewhere, it's not a complete image unless we also take account of examining every tree on the mountainside and working out which of them need to be captured and presented in a picture so that we can appreciate every step up the mountain. Joseph, I'm not going to intimidate you, or not that I imagine anybody could do that, nor embarrass you by all your many accomplishments, but it's a great pleasure to have you with us. A very, very warm welcome. Please start.
Thank you very much indeed, and it is a great pleasure to be here. And I've come a few days ago and discovered much more interest in being here than I anticipated when I accepted the invitation. So I'll be, I'm leaving Singapore more fascinated by it and more eager to know more about it than when I came to it. As you see, you have the slides and the stuff which will hopefully flick in front of you over there will just be the slides. But I thought, I'm generally a great believer in outlines, but I thought when we have both a PowerPoint presentation and an outline, they should be identical. There shouldn't be conflict between them. And this outline, like any outline, is a very good idea because it leaves lots of space for you to jot in your own thoughts and reaction. And as you see, I call this a speculative reflection, which means, among other things, that there wouldn't be all that much detailed examination of any trees. It will be more of a kind of loose and broad survey of the terrain. And I thought that it might be nice to focus it on this issue. You will see later on why I think the issue arises for us, particularly today. But in fact, it's an issue which should have arisen for legal theory at any time. And surprisingly, it doesn't arise often enough. Now that may be because I keep great company and the people with whose work I'm not that familiar do discuss it much more. But the people whose work I was more directly familiar and influenced by do not, on the whole. They take it for granted, and it seems that it is a question which is important. It's a question both about legal philosophy, kind of meta question, about why legal philosophy, or so much of it, takes a state or state law as paradigm example of law. But it's also thereby a question about the state. What is it about state law which might merit that standing as a paradigm case of the law? And of course, it's a critical question. When you open it up, you are opening it up with a possible view to saying it was all a big mistake. It shouldn't have happened like that. But even if you do not end up with that conclusion, I think the very examination of the question is likely to make you see state law as still as paradigm, perhaps somewhat differently and hopefully in a somewhat improved way. So that's kind of the hope, of course. There's no end to the journey on my part today. It's just trying to chart the road to an exploration. And a really radical approach would have said, okay, we start from scratch, we just look at the phenomena and we are trying to find how to analyze it and how to proceed. I'm not going to do that. I'm going to use building blocks, as I call them here, which have been used in legal theory, which you will be all too familiar with. So they are open to revision. The fact that I'm using existing building block and not starting with the examination doesn't mean that the inquiry cannot challenge them, cannot lead to saying they're inappropriate, they lead to a dead end or something. However, it does tilt the inquiry in certain directions, there's no doubt about that. And it also has the results that half my talk will be familiar to you. So if you want to go out and get some more food and come back when I'm halfway through, you're welcome to do so. So just to anticipate, my inkling, my thought was that theorists take the most comprehensive legally based social organization of their day as their focus, as a paradigm. And we are used to legal theory focusing sometimes exclusively on state law, because for quite a while the state has been, or was assumed to be, rightly or wrongly, the most comprehensive law-based social organization in contemporary world. And so that's what I would want to explore. Is it? And is it a good reason for taking it as paradigm? But I have to say, I'm not going to say much about is it a good reason for taking it as a paradigm. If it is that, the most comprehensive legally based social organization of the time, I'll kind of assume that will be understood as giving it some special place. And the state's standing depends on the combination of two factors. The idea that it is such an organization. One is extensive responsibility within the organization's domain, and secondly, freedom from external legal constraints. So you can see already in these formulations, even though, say, do not quote any existing writings that I'm aware of, but they sort of track familiar ways of thinking in legal theory. So I said I'm going to start with familiar building blocks, and the first one is an idea that law has a lot to do with practice-based rules. Say the law has a lot to do with practice-based rules even though we don't get to law or legally related phenomena, if that's all we have, they are much more fundamental building blocks of any social life. And I think you find them among some animal species, other animal species, not only Homo sapiens. But given that they are so fundamental to social life generally, they're obviously fundamental for legal structures as well, and it's worth reminding ourselves or recalling some of their basic features. Oops. Sorry, I just remembered that in this document I told myself at what pace I should go, and that he will warn me when I'm falling behind. Anyway, so some familiar features of them, and so a lot would be known to you, all of it will be known to you, but the emphasis might be a bit different than in some other places. So the first and fundamental point to my mind is that both in the life of individuals and in the history of societies, people learn that there are rules addressed to them, and learn, not only in the abstract proposition that there are rules addressed to them, they learn of rules which are addressed to them before they acquire the ability to understand their point and the possibility that they are not justified. They just grow into them. They are habituated as either as children in their own society or later on as immigrants to another society. Their learning is not explicit learning predominantly, but implicit learning, and they acquire much more knowledge than they know they have acquired through it. And it comes, the habituation comes as taking certain things for granted. But they are normative things that you take for granted. You take for granted that you knock before you open a door, or things of that kind. And you do this long before you even realize that maybe it's a silly idea to do it. And that's, by the way, why, and we learn about them because they are not standalone rules, but they are embedded in social structures, in forms of life, call it what you like, in real social relationships, like the family. So any family life has a huge number of rules which constitute the family relationships. They're not single rules, but they are a whole bunch of rules. And it's very important because it means that we are both habituated into attitudes to families as well as to the rules which constitute families. So our attitudes to the rules is not separate from our attitudes to the head of the family or to siblings or to other members of the family. Whether or not we are likely to be happy with the structure depends, as an abstract structure is likely to be interrelated with our happiness and attitudes to our own experiences with families. And the thing is that this is why I call them rules. This is a remark only to people who are silly enough to read stuff that I've written before. To my mind, there is a difference between rules and ordinary reasons for action. But ordinary reasons for action, the very ability to muster the concept comes when you understand that it has to be justified, that you can ask questions whether something which somebody says is a reason for doing something is really a good reason for doing it, and you understand that there are conflicts and there is a matter of choosing sometimes between deciding which of conflicting reasons one has to follow, whereas in our habituation and learning of normative phenomena in the first place, this is not yet there, this comes later. They come as fixed demands, as it were, which are kind of more appropriate to regard them as rules. And I mention here that I call them practice-based rules to indicate that the content is fixed by social practices. And being a practice consists of patterns of behavior that are fairly general and known to be general, and known to be known to be general, and so on ad infinitum, if you like. And they include behavior of conforming to the rule, but perhaps more importantly, behavior expressing sincerely early attitudes that imply that the rule is to be taken as binding and as providing a strong reason for action. You see why I hedge about using reasons here. I did use a term, but strong reason, kind of. Perhaps I shouldn't have used the term at all in the first, for the first habituation into the phenomenon of rules. So they include attitude which imply that rule is to be taken as binding by those to whom it applies and to be acknowledged as binding by others. There's no requirement, it's not part of the idea that the population that I'm talking about here are also subject to the rule. There could be rules about foreigners, but visitors who don't even know that there are rules applying to them. And not implying that either that the rule derives truth, validity, or justification from being practice-based, only that if you ask what's the content, then it is determined by the practice. So it's not the same as conventional rule in the common understanding. Conventional rules are those which you follow because other people follow them. The justification is that they ought to be followed because other people follow them. Here, the motivation, whether they have justification or not, the motivation is bound up, as I said, with attitude to one's experience, to the social relationship which they constitute. Okay, enough of rules. We get to this traditional view. All traditional views are disputed, not only because they are traditional, but sometimes because they are traditional. We had reason to oppose them, but sometimes felt as compelling by some. The traditional view in legal analysis, much legal analysis, is that we get to something like law, I call it law-related structures of phenomena, once we get institutions into the picture. And institutions, I don't want to say anything particularly interesting about those institutions. I will use common, familiar terms. But the idea is that the institutions are ultimately governed by practice-based rules which determine at least the most important aspects of their constitution. So this is meant to allow for them to be, think of institutions governed by the constitution of some institution to be living constitutions. The content is determined. The rules governing the institutions change from time to time, and not always by general practice, but important aspects of them are determined by general practice. And I kind of list a classification of rules of a familiar kind. To me, the classification doesn't matter. There might be better classifications, either more detailed classifications or completely different classifications which reject those between law applying and law creating, adjudicative or enforcement powers and all that sort of stuff. That's kind of secondary. What is more important is that the institutions are there, and this point that I want to make here is that when we have institutions, even when we do not have legislative institutions, if they are widespread and elaborate, then they would lead to changes in the rules independently of changes in the practices. So they may have a task to adjudicate or whatever, enforce practice-based tools, but in doing so, their own activities will change over time the content of the rules that they apply, and that's because the mark of those institutions is that their decisions bind even if mistaken or judged. Otherwise, they're not institutions. That's what makes them into institutions, that they have the authority, power, normative power to make binding decisions. They may be subject to appeal or to other forms of rule-based challenge, calling for the review and so on, but subject to that, they are binding even if they are mistaken. You cannot say, okay, the institution has decided against it, but that was a mistake. If you say that, you deny that the institution is an authoritative institution. You can say it was a mistake. Sorry, I didn't. You cannot say it's a mistake. And you cannot say it's a mistake and therefore it's as if it didn't happen. I'm just trying to ignore it. It's okay to say it's a mistake, but then you have to follow, but unfortunately I have to give up my car because of the mistake. So, okay, again, you know that there'll be, in complex cases, hierarchies of institutions, and I don't want to spend time going into that. It's familiar ground, not specifically crucial to my question, why the state. So it's important to do it, but don't have to do it now. And we have to realize that this is deliberately a very inflationary idea of law-related structures. So we call it a family is a law-related structure, provided it recognizes authority of some of its members over other members, which is fairly common, if not universal, in families. So it's inflationary deliberately. It wants, of course, to come to the state, to enable us to ask questions about the state. So it wants to be the sort of framework that state law, when I say state, I mean state law, that state fits in, but it doesn't want to be tightly drawn around the state, thus prejudging the issue whether the state should be the paradigm case of law. So it's deliberately meant to be very loose and very wide in order to leave that question open. Now, I already remarked that the institutions lead to changes in the practice-based rules, even though it's not a function to do so. It does happen. They change the content of the rules, and whether or not the practice follows their decisions becomes a moot point, a contingent matter. Sometimes it does, sometimes it doesn't. The reason I highlight it in this slide is because early on I emphasized that rules are not standalone normative sort of creatures. They are embedded in social relationships, and our attitude to them is part, and to a very large degree, shaped by our attitude to the social relations as we experience them, as we live through them. In a complicated way. I don't mean to say that if you quarrel with your mother, you then reject the institution of the family. You might become a very orthodox adherent to the rules, blaming your mother for deviating from them. Or you might want to say, no, your mother was saintly, but she was caught in a social network which did not allow her to behave in a proper way to her children, and the rules are to blame, and you want to change the rules. So there's no one-way traffic between attitude to the rules and your understanding of the social relations and your experience with them. But it's very tightly bound up with them. And I say this again and again. I've now said it 3 times in 10 minutes, 12, 15 minutes. Because while I don't want to ignore the importance of specifically provided incentives in the rules, what sometimes is called sanctions, I think that we should not kid ourselves into thinking that they are the determinative motivator for the survivability and continued existence of the rules. And I think, most people who reflect on this come to the conclusion that when the life of the rules turns primarily on those incentives or on sanctions, something has gone deeply wrong, and we are in this state of degenerative decline. So that's why the institution creates a problem, because it changes a dynamic. Now, attitude to the institutions take on from attitudes to the rules as a sustaining element. Lots of people obey the law to go to legal institutions because they respect the government. And lots of people disobey law in a way which does not serve any rational purpose. Doesn't serve any profit motive or anything like that, simply because they resent the government, despise the government, and so on. So it then becomes, as it was important earlier in the first building law, that the structure would be sustained by positive attitudes, by a complex attitude, one which both sustains and reforms the rules. So it becomes important when we think about law-like institutions that we will have a dialectics of that kind focused on the institutions, and they take a lot of the heat off the rules. Lots of people who resent rules will be willing, or disagree with rules, will be willing to be quite faithful to them because of their respect to the government. If they lose respect to the government, they're likely to lose respect to the rules and so on. So it's a complicated story, but it's important to remember it. It's important to remember it when I come to my real topic. And finally, I'm coming close to it. So I said that the question is, so I sort of try to identify what I regard as law-related structures and institutions in a very vague way. So there's much more detail in the paper. This is not meant to be a substitute to the paper. This is meant to be an appetizer. Okay. There's much more detail in the paper. But the idea was to get to this point and then ask whether of the many law-related structures that we have, is there anything special about the state? And I said that legal theorists normally assume, rarely ask explicitly, but normally assume that the answer is yes, because the state is the most comprehensive legal system within its domain. And I take this, as I mentioned earlier, to combine two elements: extensive responsibility within its domain and freedom from external legal constraints. So I'm looking at what these amount to for a moment. Extensive responsibility within the domain. First of all, we have to know that they are relative to the domain. So different legally related structure will have different domains and they will be overlapping. And we are looking within the domain. So suppose we are looking at a small corporation or university, which is run like that, or a small country like Vatican City. We are asking whether within its domain it is the most comprehensive and independent institution, and it may compete with much broader institutions, the Italian state or international organization or other thing. But if they win, they have to win within the domain of the Vatican City, right? So it's not just competition within structures which share the same domain, but it is relative to the domain. And the elements are of, say, extensive responsibility is a range of normative powers that it has. They are typically coupled with duties to exercise them in certain ways. And that combination, normative powers and duties to exercise them, is accepted as legitimate by those subject to them. And this is regardless of why it is acknowledged to be legitimate. It can be acknowledged to be legitimate not out of love, but out of various other, in a variety of ways. From external legal constraint is a normative legal condition. It can exist to various degrees. So I mentioned here conflict of laws, in which are cases, just one of a variety of instances in which a state law acknowledges that other law has authority within it, not regarded as a threat to its standing as a state law. And the final element is that it is generally recognized beyond the system, either by the domestic laws of other institutions. I'm sometimes using legal phrases prematurely because we haven't yet indicated the law state as a paradigm case, but you will know how to broaden their application. So either by the domestic law of other structures or by sort of international laws. And this is the analog of the acknowledgement in the first part, the extensive authority inside the domain will require acknowledgement by those subject to the system. The independence of external legal constraint goes along with recognition of that by external bodies, external structure. So the question is does a state meet those conditions? And the first point I felt myself obliged to make here is to say, well, it's actually not one question but two. By now you are familiar with my tendency to divide every question to two questions. And that is the very reason why that question is more likely to be asked now than it has been, say, 50 years ago, is because there is a sense abroad that things are changing. And that change might make us revise our views about the state. And then the question is, how does it revise our views about the state? Does it revise them retrospectively, or does it say, well, from now on it is no longer, does no longer enjoy that standing. And it can revise it retrospectively. The changes which occur can lead us to kind of like a change of gestalt, to look at all the factors which led us to say the state law is paradigm case, as well, this was because we were kind of hooked on a certain gestalt, and now, given the changing circumstances, we can see differently, and we can project that way of seeing backwards, and arrive at a unified theory of law in which the state is not law at all, or more likely not the paradigm case of law. So we need to ask the two questions separately, and you might say that given that possibility that I just mentioned, I should start with the future and then ask, how has the change passed? But I haven't thought about this when I wrote the paper. So given that that's the order of slides that you have, I'm going to start with the past. Well, and again, okay, so there's a lot about this in the written paper, and I'll be very brief here. Sorry, I've been so brief that it's on easy one in that slide. So we need, about the past, the question of independence is very often thought to have been settled by the Peace of Westphalia. Now, as far as I know, Peace of Westphalia did not apply to the city-state of Singapore. There is so I'm asking from now on, this is part of why it's a speculative reflection, questions which are factual questions. And it's sort of delicate, the methodology of dealing with them is kind of delicate. This is the earlier state that I mentioned, I think, in the paper itself. So I'm not making the claim for any legal structure before the European post-Reformation and post-religious war period. So neither for European structures or for structures anywhere else in the world. I'm assuming that the legal theories that we operate with now are themselves, though not without antecedent in earlier times, some of them, you know, more impressive than any later legal theory, but they are the ones that we, more contemporary ones, the more recent ones, are informed by, addressed to a social reality which is not as old as is sometimes assumed. It can be applied retrospectively, and it is applied retrospectively by theorists to an earlier period in various parts of the world. But one has to be very careful in doing this, and the results are always more approximate than when we apply that legal theory to the reality which bred that legal theory, more contemporary, more recent reality. I'm also making the assumption that a lot of the developments, historical developments in the world in the last 300 years, 50 years, something like that, to the extent that they were driven by interaction among different bits of the world, were asymmetrically influenced by the European experience in the first instance, and by the experience of the European and the Americas in later times. So that if you trace, say, developments in Japan, you cannot ignore authentic Japanese history, but you cannot understand it from a certain point of view without American influence on Japan or German influence on Japan and so on and so forth. So there is an assumption that certain developments in certain parts of the world led to other developments, similar developments in other parts of the world. And so that's why a piece of Australia might be relevant to Singapore as well and other countries which were not subject to it at the time. And so it's taken to have established the equality of states and their independence, the duty not to interfere in their internal affairs, to use the hackneyed phrase. And from that time on, we also have, not because of it, but parallel development, we also have a domination of the state over religious institutions within its domain and other bodies which could have rivaled it, and it establishes its paramountcy as a most extensive responsibility. I actually think, though I'm not going to talk about it now, that the extent of its responsibility has been, the understanding of its responsibility, the range of its responsibility keeps growing even today. So that's why I think that it was not unreasonable to take the state as a paradigm case of legal structure, of law. At least until the last 50 years. The question is whether what is happening now, what will happen in the future, should lead us to revise that view. And I left my crystal ball away, and it's even more speculative here than anywhere else. The difficulty is both to identify the relevant developments which are taking place, to assess their prospect, how temporary, how stable they are, and then to interpret their significance. The ones that I briefly mentioned in the paper, all in one way or another are owed to globalization, understanding by globalization something much broader than just economic globalization. And while I think that the process is far from steady, one directional, I think that it is here to stay, and I'm not qualified to argue for that. You need people who know more about this world than I do to argue for this. So my hunch is that the way that globalization has manifested itself in the last 50 years may change, and in many ways I hope they will change, and that's neither here nor there, but the trend itself will remain, and the trend is what matters. Which are the relevant developments there? Well, I'm going to be very brief here. There's a lot on that in the paper. I mentioned three trends. One is the emergence of international organizations with independent lawmaking powers that are not conditional on consent of states subject to them. And I have in mind both regional organizations, the paradigm case being the European Union, but so are other regional organizations, and also other organizations, international organizations, like, again, one of the most powerful is the WTO, but there are lots of others. And somebody might say, oh, they're all treaty-based. Yeah, they're all treaty-based. Treaty is a matter of the consent of the state. Yes, treaty is a matter of the consent of the state in a formal sense. What I mean when I make the point here is that there is no sensible theory of when consent matters, what you can consent to, and we all, I hope, know that you cannot consent to everything, not in a binding way. So agreeing to sell yourself to slavery is kind of a standard example. It cannot be a binding agreement. So my claim in that first point is that there are no normatively sensible theory of when consent is binding, which would regard the powers of those institutions to make and change law and transform the nature of the institution based on the consent which created the institution in the first place. Those of you who have the tendency to, kind of pessimistic tendency to read bad news and follow developments in the United Kingdom will be hearing weekly how government officials and so on keep complaining that the European Court of Human Rights is no longer what it used to be, that it's not what the member states which of the Council of Europe which created the treaty and the states which ratified the treaty thought they were agreeing to. And they never think that the people of the United States might say the same, that the Constitution of the United States is not the Constitution that the people who voted today is not the Constitution that the people who voted for it thought they are voting for. That's the nature of the law, and it shows that in international law we have reached that stage where it's no longer based on treaty, the traditional understanding. Second feature is that there are changes in the way in which customary international law emerges. There's a lot of writing about this, and I hope that the international lawyers in the discussion will explain this. I'm not going to go into this now. I don't want to take the most extreme view on this, but I think there is some truth in the claims that this has changed. And the third is that we have new agents who can act directly in their own name in international law, including individuals. And all this shows radical transition in international law. So what are the implications to the theory of law? Well, as was anticipated by what I said earlier, I regard the theory of law as based on two doctrines, doctrine of legitimacy and doctrine of sovereignty, legitimacy inside and sovereignty outside. I'm not going to elaborate on what they are. I just want to highlight again one fact, that what I call the perfect match theory, which says that you are independent from external interference in all the area where you are legitimate internally, is appealing as it might be intuitively, is completely wrong. You can have authority without independence, and every court other than the Supreme Court, any court whose decisions are subject to appeal, not only the Supreme Court, is an example of that, right? They have authority within a certain domain, but they're not independent. They can be appealed against. So the state can have legitimate authority within a wide range of domains, all the domains that we have come to think of it, within its authority, while not being free from appeal to international tribunals or other international organizations, as is the case today in many areas. And on the other hand, I think that sovereignty can be wider than the range of internal authority that the state has. For sovereignty to be limited, you must have some normatively decent institution, reliable, objective, dedicated, and so on, whereas features which will make it worthy of being such an international institution, which can set the limits, which can override the limits or set the limits to state sovereignty. We don't want to give external bodies a right to interfere in matters within the state if they are not capable of doing it in a fair and reliable way. The fact that state institutions cannot do it, that they assume to themselves more authority typically than they are entitled to, is regrettable and should be corrected, but not corrected by giving other institutions outside the state which do not deserve that standing the power to interfere within the state. So the two questions of the range of the authority of the state, legitimate authority of the state, and the range of its sovereignty should be kept separately, dealt with separately. Now, so thinking about the state in light of the developments which I highlighted, the first thing to say is that there is no rival to the states. There's no development in international relation, in international law, in international morality. Wherever you look, there's no development which leads to the emergence of any legal-like institution which can take over from the state. The closest to that are the regional organizations, and in quite a number of them, in all of them, there is strong resistance to them assuming that position. They are welcomed as regional organizations, but not as substitutes to the state. So what we come to is that the state, there's nothing in the developments which would suggest that the state will lose its standing and be replaced by something else. But I think that there is a lot in it which suggests that it will change. It will have more constrained legitimacy, in that more and more it will be required to conform, and it is already required to conform with international standards. In some areas, national parliaments are not aware of it, because national parliaments are responsible for about 1 to 2% of the law of many states. The developments which happen through international organizations which regulate terms of recognition of negotiable instruments, or terms under which the internet is working, terms under which aviation is working, an endless number of areas of life without which our life would not be what it is, are not within the awareness of democratic politics, let's call it broadly, except occasionally, of course. It can always be that something which happens here, I'm trying to bring the example which my partner suggested that I bring up, which is that it is very important to find international action, which can be found only through international organizations, to protect the potency of antibiotics. Using antibiotics will be a terrible threat to human health worldwide. Cannot be done. They are in great danger, partly by irresponsible use of antibiotics by doctors and individuals, but mainly by the agro industry, who feeds livestock with antibiotics instead of giving them decent standard of living, and thus degrading the power of antibiotics. So this is typically something which normally will not become politics. It will be done by committees of experts, by the international health organizations. However, the agro-industry is likely to make it a matter of politics, not necessarily directly, by saying, yes, we don't mind about antibiotic, but by financing in the countries where corporations can freely finance candidates in election, financing candidates who in return will vote against any agreement. And indirectly democratic politics will undermine the development in that way. So that's a way in which there is kind of a complicated relationship between this constrained legitimacy, which I said, that the government have all the powers that they have, but within the constraints of international agreements and international law and politics. And the other side of it is reduced sovereignty, which is obvious. But in all those matters, the state will remain the focal legal institutions with reduced standing and much more firmly embedded in the future within a network of international organizations, not one but many, which enables me to avoid various issues about fragmentation of international law, because it doesn't matter. There will be international institutions and the state will be embedded within them. Thank you very much.
Just pause for the technical crew to